Welcome back. You are on Rights and Recourse, and we are discussing the credit amnesty information that is amnesty. That's what I wanted to say. And with Stephen Logan here with me, and in our Pretoria studio is McDonald Neshitenje. McDonald, quickly, I just want to start with you. I want to come back to Stephen on something that we were talking about earlier. But first of all, why is it taking so long for a debt that has been prescribed for the adverse information to be removed? Is this going to make that happen much quicker?
No, thanks, Mr. Mateza. If I understand your question, if the debt has prescribed, generally is say 3 years, so the debt is dead and nobody should effect any payment because the debt is dead. But what is happening is that you may find that the credit providers, even if they know that the debt is dead, they will go behind the scenes and persuade the consumer to pay maybe 10 rand, a debt of, say, 10,000. And then if the consumer effects that 10 rand, the debt is revived. So because of this education and awareness, consumers should be told that that will be illegal for the debt to be resuscitated when it has died. So therefore, the issue of consumer education should be emphasized.
Stephen, it does happen, as McDonald puts it, that you get credit collectors who buy debtors' books, and they, after they've bought the book, then they check how they can make money out of this, and they chase the money. Is that allowed?
Look, prescribed debt is often sold, and it means that there are many debt collectors or credit collection attorneys even who go and try and collect on that debt, even though it's dead, as McDonald explained. Because if they can get you to make a small payment or acknowledge that you are responsible or liable for the debt, then the obligation to make payment comes back. The debt revives. So for them it's a very good business to go and buy old debt and then to try and collect on it. And it's possible that even some of those listed old debts can be listed on your credit record. But if you bring that to the attention of the credit bureau and you say, look, this debt has prescribed. The last time I was meant to make payment of this debt was over 3 years ago. Then they will investigate, and they must, by law, remove that information because it's incorrect. You do not owe the money any longer. The key thing consumers have to bear in mind is that they need to make sure they don't admit liability for an old prescribed debt.
There are two areas I want you to talk. First of all, I just want you to just re-emphasize the issue of we spoke about earlier, your affordability. How do you do, whose responsibility is it to do the affordability test? Another one is, of course, you can tie these two questions together, is it would seem to me that credit bureaus are very reluctant in educating the consumers about their rights. Why is that?
Well, as McDonald explained earlier, there's a real need for consumers to understand how credit will affect them and what they can actually afford and what they can't afford. Now, credit providers have not really taken it upon themselves to explain affordability. And there's a requirement that's coming in now from the National Credit Regulator to explain affordability. So I think that the two questions are tied because credit literacy is a very big topic. And we need the credit bureaus and the credit providers to not put up signs in their branches saying, ask me for a loan, but rather to put up signage that says, tell me whether or not I can afford the credit that I want, or explain to me how I can use the credit in a better way. Because if we are using credit in a more sustainable way to buy durable goods, to buy things that appreciate in value like property, then we'll do better. But when we use credit to buy food or to buy fashion, then it's a problem because it doesn't give you a return on your money.
There's something else that is a sting in the tail that I have experienced recently, and that is whenever a judgment has been rescinded, why is the onus on me, on the debtor, to prove that this debt has been paid and the adverse information must be removed?
Well, you know, the DTI should be commended because the DTI have said if a judgment debt has been paid, there's no need for you to go to court following this amnesty to have the judgment cancelled. At the moment, if you have a judgment but you paid the debt, you still have to go to court to have the judgment cancelled before the Credit Bureau will remove the notice of the judgment from your credit profile. Now this is a big advance because for many years there's been a huge cost to removing this judgment information from your credit record. You will not have to do that anymore. If you can show that you have paid the judgment debt, then the Credit Bureau will have to remove the judgment from your credit profile. And that is going to benefit many hundreds of thousands of people.
The other thing, Mr. Netshitenzhe, I just want to come back to this issue of the recommendations. How far do the recommendations go in accommodating the consumer in terms of the consumer being creditworthy again?
Yeah, the recommendations are multi-pronged in a sense that 1.6 million at a go will benefit. And then on a continuous basis again, they will benefit. So the recommendations, therefore, through this notice will go far enough to remove this adverse information, and therefore the recommendations will be put into effect in so much that therefore if one looks at other jurisdictions, it has been done. Jurisdictions, we mean countries like Brazil as an example, because people think this is only a South African style of doing things. No, other countries are doing that. I'm quoting Brazil here as an example, and therefore the affordability test will have to be done jointly by the consumer, as Steve has said, as well as by the credit providers. So everybody should be telling the truth, and therefore we find our economy going well. So the recommendations are well placed in order to relieve these debt-ridden consumers.
Stephen, what I cannot get over is there seems not to be a pulling together here by all parties. A day after we have set this interview together and this was released, all of a sudden we were going to have the CBA coming here, and then the CBA pulled out and said they issued a very strongly worded statement, which we have not received, by the way. Why is there some people pulling the other direction?
Well, I think that there's genuine concern on the part of the Credit Bureau Association and on the part of other large credit providers and their industry associations that the DTI or the NCR are doing something that's negative for the credit industry. But I honestly believe that they haven't had the opportunity to really engage, or not that they haven't had the opportunity, sorry, that's incorrect. They have definitely had the opportunity to engage, but they haven't engaged. So many of these large credit provider forums or industry bodies, including the CBA, want to protect their turf. And I think that they needed to come forward earlier in the process and really try to be more constructive than they have been. That's my personal view.
Mr. Netshitenzhe, is there room for probably these people who are opposed to what the DTI and the government is doing, is there room to go to court, to get a court order around this issue, to challenge this in court?
Yeah, approaching a court is a constitutional right, but the issue is that will you win that case? So we should not play in the courts. We are of the view that we are doing things legally, constitutionally, and therefore